right, so this chapter, how can I say it? It's probably the most important chapter in the whole book. Only because most questions in the state exam refer back to this somehow. Chapter 11, 10, 11, 12, always come back to this. Chapter 1 and 2, go back to this. Does that make sense?
Yeah.
So a lot of terms from yesterday, you're going to recognize them today. And it's going to start becoming a lot easier for you. Okay? As you go.
Okay.
And you stop me at any time that you have questions, okay? Because I know this is going to be a tough one.
Okay.
So on the next page, we have brokerage defined. So brokerage defined. The business of bringing buyers and sellers together in the marketplace is called brokerage. So when you have something, and I'll give you the example of a Walmart, for instance. Walmart's a little different because they buy the inventory. But let's imagine they have Walmart, but none of the inventory is theirs. What they're doing is brokering for the suppliers, like Colgate or Listerine or Scottex, whatever it is, right? They just put stuff on the shelf. Buyers come in, they buy, and then they pay whoever supplied them. Does that make sense? So Walmart would be kind of a brokerage. In our business, it's a little different. We have a seller, we have a buyer, but we don't sell and we don't buy. We're just helping. So we broker the deal for them. Does that make sense?
Yeah.
We matchmake, right?
Yeah.
So in real estate business, a broker is defined as a person who is licensed to assist others in real estate transactions and to receive compensation for those services. A real estate salesperson works on behalf of and is licensed to work under supervision of a
Broker.
And who's this broker?
Of record.
Of record. Because I know yesterday you're like,
Yeah.
That says years ago in New Jersey and elsewhere, the principal known as the client, who employed the broker, was almost always an owner who wished to sell a property. So the real estate broker acted as a seller's agent and was usually compensated with a commission if a ready, willing, and able purchaser was procured. In this traditional real estate transaction, the seller was the client to whom specific duties were owed, and the buyer was the agent's customer, whom the agent must only treat fairly and honestly. So what we're saying here, before I move forward, is that until not too long ago, sellers were represented, buyers weren't. So if you wanted to sell a house, you would use a broker, put the house on the market, buyer would come in, buy, and that's it. Okay? So the seller was my client. And because the seller is my client, every time you see client means somebody that I owe duties to, meaning it's them first, then me, then everybody else. So if a buyer came along, they're there. I got to treat them fairly and honestly, as it says at the end, right?
Mm-hmm.
But my client's up here in the pedestal. First, my client, okay? So today, agency relationships have become more complex than under the old seller-based model. A prospective buyer or a person seeking property to rent can also be a principal and hire a broker to act as a buyer's broker or buyer's agent. In this type of relationship, the buyer is the client to whom specific duties are owed, and the seller is the agent's customer whom the agent must simply treat honestly. So it's the roles reverse. If you're a buyer and you come to me, hey Bruno, can you help me buy a house? Right? Mm-hmm. I'll help you find the house for you to buy. You're my client. So now you're up here, I'm here, and the seller is down here because you're first. Does that make sense?
Yeah.
All right. So the next thing it says is that it's also possible for a licensee to function as a transaction broker, working with a buyer, seller, or both, but underline this, without representing either one, but functioning as a manager of the transaction. So in this case, no agency relationship is created, right? What we're trying to say, I mentioned briefly yesterday, what we're trying to say is, I represent the transaction. I don't represent you, the buyer, I don't represent you, the seller. I represent the transaction. So anything you tell me or anything you tell me, I might kind of use for the deal to go through. Does that make sense?
Yeah.
I still cannot defraud you by saying, hey, there's no damage to this house.
Right.
But I might use some information to go back and forth. Does that make sense?
Yeah.
I don't represent you, so you cannot sue me. Well, you can, but not to the extent of you're my client.
Okay.
Then it says the creation of agency is determined not by who pays the commission, but in most cases by a contractual agreement between the broker and the buyer or seller. So my question usually is, who pays the commission? The client or the customer? The seller or the buyer?
Buyer.
Buyer pays commission?
No. I mean, it depends. No.
Right? Depends.
I don't know, the customer, he's gonna pay for the commission, no?
Okay.
Ah,
So let me put it in a different way.
okay.
If you work at Walmart again,
Mhm.
who pays your salary?
Walmart.
Who employed you?
Walmart.
Walmart, right?
Mm-hmm.
But that's because the contract says so. What if you're commission based and it was based on every sale? It could potentially be Walmart, or you could take your salary right like tips. Take the tips right there and then. So who paid you the tips? The customer.
Right.
So the thing is, it depends, it says right here, it depends on the contractual agreement.
It has to be written.
So you could be employed by the client, which is Walmart in that case, but the customer already agreed to pay if it's tips. See what I'm saying?
Yeah.
In that sense.
Right.
In our scenario, in real estate, usually the seller is the one that pays commission because we negotiated at time of listing a standard of 6%, right?
Yeah.
There is no standard. So we negotiated 6%. What was that 6%, for instance? That 6% was to split between the listing agent or listing broker, I'm sorry, and the selling broker, whoever represents the buyer. Does that make sense?
Yeah. So it gets
So-
split in half, basically.
Correct. But well,
Whichever
whatever
way.
the agreement is.
Right.
So let's say you represent Allie. She's the buyer, you're the agent. I represent the seller. My seller, my client, already agreed to pay me, and from that payment, I split with you. So Allie's not paying you anything.
Right. Okay.
She's your client, she's my customer. Just like, right, this is my client,
Right.
right? But your customer.
Right.
You guys understand what I'm trying
Yeah.
to say?
So it's like I said, a triangle effect, kind of.
Kinda.
Okay.
So payment is based on a document that says, hey, I promise to pay you.
Okay.
That's it. It's not based on who you represent. It's based on who agreed to pay. So sometimes the customer pays, sometimes the client pays. It depends on who agreed to pay.
Okay.
Contract, always. All right, what we got next? Agency. Oh, actually before that, so who's the client?
The client is the person who's selling the house,
Ah,
right? Which is the seller,
uh-huh.
depending
It depends.
if you're the realtor for the seller or you're the realtor for the buyer.
Yes. So the client is who you represent.
Right.
If you want to write that down. The client is always who you represent. The customer is the other party who you don't represent. Okay? Client is who you represent. Payment is based on contract. Client is who you represent. So if you represent the seller, if you represent the seller, sells the client. If you represent the buyer, buyer's the client. If you don't represent either one or any of them, then they're customers.
Okay.
Okay? That's very important. Okay, agency. So the role of a broker as the agent of his or her principal is a fiduciary relationship that falls within the requirements of law of agency. A fiduciary relationship is one of trust and confidence in which the agent is responsible for money and or property of others. See, when you represent somebody, they trusted you with their assets, whether it's money or property. In this case, representing the seller, it's the property. Representing the buyer, it's the money and potential property. Does that make sense?
Yeah.
So they trusted you. So it requires that the principal interest is above all others, including your own. Unfortunately, a lot of salespeople and a lot of brokers, it's like me versus client. So instead of helping you get the best for your property, they're looking at, okay, if I show this house, I make this much commission. If I show that house, I make this much commission. And unfortunately, that's the way it goes, right?
Yeah.
But in reality, agency and how you can sue them or get sued is, did they have me in mind first? If not, they broke the fiduciary relationship, and they might have to return commissions. They might be sued up to 3 times the value. We'll talk about it in Chapter 11. But it's very important that you know Once you represent somebody else, that's it. It's them first. Okay? Next, we have type of agency. So I'm going to go through all three of them, and then I'll explain, okay? So first we have universal agents. So universal agent has the authority to represent the principal in all matters that can be delegated. It says he or she, then on top, can enter into any contract on behalf of the principal without prior permission. The next one is general agent. This is empowered to represent the principal in a broad range of matters. And the general agent may bind the principal to any contracts within the scope of his or her authority. And the next one, special agent. A special agent is authorized to represent the principal in one specific capacity only. So between these three, universal agent, like your mothers, so you're universal agents. Meaning, while your kids are minors, we do everything in their best interest. But do we ask permission to our kids? Hey, what do you think about me signing you up for college? Or, as an example, what do you think about me buying the house in this neighborhood? We don't ask them. We just say, hey, we're going to do this because it's best for you, right? You moved your daughter from a high school to a different high school. Why? Because you thought it was better.
Yes.
Did you ask opinion?
No.
You said, I'm doing this.
Yes.
So universal agent has full powers to do something on behalf of somebody else, as long as it's in their best interest. Salespeople, we don't have universal agency. We're not. But you look at medical directives, you look at executors from wills, right? They have the power of making decisions for somebody else, as long as it's in their best interest, okay? The general agent, so if you want to write universal, write full powers, okay? A general agent, in this book, it talks about a property manager because it operates in a similar way. See, a property manager does not handle one thing, does not have full powers. Because if I'm the property manager of this building, I cannot sell the building without talking to the owner. If I was a universal agent, I could do whatever I want as long as it's in their best interest. I don't need permission. General agent, you have some powers, not full powers. Okay? And the last one is a special agent. So that's where most realtors, salespeople, brokers are involved. It's special agents because they work in a specific capacity. That means one thing only, one purpose only, a specific purpose only. So if you're representing a seller, what are you hired to do?
Represent the seller, get the better interest for the seller.
Okay, but what's that?
Well, sell the house or whatever it is.
Sell a house. So we hired to sell.
Well, and get deals. I don't
Okay.
know.
All right. See, I mentioned earlier, we don't sell, we don't buy. We help the seller sell, we help the buyer buy. So when we represent the seller, we help them market their property in order to get sold. But if I represent the seller and trying to sell this, right, the contract is specifically on this.
Right.
My job is to market this to the best of my ability and get it sold for the best price possible in their best interest. As soon as this is sold, does my business relationship continue?
No.
No, it's over. This is sold, we're done. General agent, the property manager, will keep on managing the property for 5 years, for instance. It's an ongoing thing. Here, we're done. You got it?
Yeah.
But can I represent the seller in this property, that property, and so on? Can I represent them more? Yes.
Yeah.
But each one of them is a specific contract. Once this is done, I don't represent in this one anymore. I'll represent in the other property and the other property. Does that make sense?
Yeah.
So we're hired specifically for one particular project. Done. Okay? As the buyer is the same thing. I help you buy, we're done with that one. Then we'll get into another one. So we can have multiple contracts, but each one is independent. All right. Next we have, right above fiduciary responsibilities, we have power of attorney. Have you ever heard of this before?
Mm-hmm.
Okay. Do you know what a power of attorney is?
Mm-hmm.
What is it?
Basically giving authority to someone else to do what's best in the interest of that person when they're not present.
No. Listen, we got to work this way. I like to work this way. Don't feel bad that you like. If you don't know, you
It's
don't
not
know.
wine. Stop being no look at me that I'm drinking wine.
I'm
Okay?
just saying share. You know. That's all I'm saying. All right. So a power of attorney is not something in the best interest. See, when I give you power of attorney, it's to something specific and it's legally binding.
Okay.
So it's not your best interest. You already set the task for me to represent you
Right.
for one specific purpose. Does that make sense?
Yeah.
The other ones, I represent you, but I don't have, I can use my best judgments.
Okay.
Power of attorney is, hey, you're going to be there for me this day signing a document that will legally bind me to whatever. But it's already specified what you're going to do.
Okay.
Does that make sense?
Yeah.
All right, so it's a little different. The other ones, if I represent you in the sale of a house, can I sign the contract for you? No. Power of attorney, you go to the closing and you sign on behalf of somebody else, and that transaction is valid. Which, by the way, if any of your clients goes on vacation, make sure they don't go without a power of attorney. And make sure you're not the power of attorney.
Oh, okay.
I mean, the attorney in fact, okay?
Got it.
Because then they can use that against you. So, the next thing we have is fiduciary responsibilities. Did I tell you what fiduciary relationship was?
You don't want to be sure.
Chapters? One of these pages, got it.
I know it was in one of these.
No, it's like the previous page, but it's okay. It's right there.
Oh,
Actually, it's still same page to the left.
never mind. Mhm.
One of these, we're doing great. One of these chapters, it's like right to the left.
We're getting there.
Right to the left.
Right there, right
Hopefully by the end we'll be on the exact page.
Yeah. So fiduciary relationship, and by the way, don't feel bad. I do this in every class. I'm just trying to show you guys that from one paragraph to another, blank. That's the importance of studying after.
Yeah.
Because here I'm just throwing stuff at you. If you don't review the stuff, how many times a week do you go to the gym?
What do you mean? How many times?
A week
A
do you go
week?
to the gym?
Depends how my schedule is. But usually.
2 times? 3 times?
No, 5 times.
5 times. Why do you go 5 times?
Because I like to work out.
Just because you like it, or because
Because I need it.
you need it? All right.
And it's something that I put in my
But if you stop going, what happens to your body?
like discipline.
What happens to your body if you stop going?
It's neat.
You
I
become
feel,
heavy.
no, I'm gonna feel like,
Me.
something's missing. Like, you need to drink coffee every day, with the wine every day.
The wine every
Yeah,
day.
then if you don't drink it, then something is.
Got it. So, my point is, if you stop going to the gym, you feel the difference.
Mhm.
If you don't keep on studying, like reviewing everything, you'll notice the difference. I just showed you right now.
Mhm.
And I'll keep on showing you guys along the way. I do this in every class, by the way, with everybody. So again, don't feel bad. I'll show you along the way that, again, from one paragraph to the other, you're lost. Because it's info coming in, and you're not processing yet. You're just, boom, boom. Your brain's trying to put it somewhere,
Mhm.
right? So fiduciary relationship, that's when you put somebody else's interest above yours, because they trusted you with their property or money, okay? So with that, confidential relationship carries with it certain duties that the agent must perform, and we call it COLD, which is care, obedience, accounting, loyalty, and disclosure. So when we say COLD, it's just an acronym. I love acronyms. So you guys can find acronyms for whatever you want, but when you represent somebody, you gotta have a COLD. You gotta care, you have to obey lawful instructions, you have to hold proper accounting of the monies they give to you, you have to be loyal to your clients, and you have to disclose everything possible that you know or that you inquired about, okay? So what does it mean to care? Let's start with that one. Anybody? What does it mean to care? Without reading? What does it mean to care?
I don't know, there's different ways of caring.
What does it mean to care? Tell me something.
No,
To
I
look
know
out
what you
for.
got here.
To look out for.
To look out for?
To
That's
look out
because
for.
care is like,
Well, to look out for in their best interest.
how you figure on me? You just got here.
That's fine.
Wow, she's like throw him under the bus, not me.
I'm used to it.
All right,
That's why
Allie,
I'm quick.
Allie, what does it mean to care?
I'm not gonna see anything. No.
All right, so the
Sounds
three
like-
of you,
Yes.
have kids.
Is it to care for?
You said look out for.
To look out for in their best interest. Well,
Usually in my classes where I have 20, 30, 40, 50 people, I'm counting the seconds for somebody to answer me what does it mean to care? And then I ask how many of you have kids? Because if you don't know what it means to care, I'm calling DIFUS. Caring is doing something for somebody else in their best interest.
Yeah.
Putting them first. That's the first rule of everything, of contracts. When you contract or employed by somebody, you put their best interest first. If you work for Walmart, are you going to do the best for the customer or for your client, which is your boss?
For the customer.
Why?
Because
So if the customer says, give me this for free, you're going to go, oh, sure. No.
well, no.
You're going to smile at the customer, treat them fair and honestly,
Right.
right? And you're going to say, hey, we can't help you, but I think there's a coupon. Let me check. Something like that.
Yeah.
But you're not going to give something for free because then your client who employed you will fire you. You see what I'm trying to
Got
say?
it.
All right. So you got to care so much that you do the best for your employer, whoever hired you. Okay? Yep. So back to caring. It says the agent must exercise a reasonable degree of care and diligence while transacting business on behalf of the principal. So brokers and agents are expected by virtue of their licenses to have expertise in real estate matters greater than that possessed by the average person, and as a result they may be liable to the principal for any loss resulting from negligence or carelessness. This is a real estate business card, right? I want you to look at it. Tell me how long he's been doing that as a realtor. How long has he been a realtor?
5 years?
Huh?
5, 10 years?
Where do you see that?
You don't.
So why do you say it?
I don't know. He just looks like it.
He looks like it, right? Okay. Alec?
Yeah, it's look like, you know, this.
5, 10 years? Okay.
No, less than that.
Damn.
Yep.
I like her safe bet. It's like 5, 10 years.
I mean, now because I know him,
Mm-hmm.
you know, more than 10 years, because now he works with you, but I know him.
Okay.
But if I don't know him, you know, because the car, you know, say like 2 years.
2 years? Okay.
Okay.
You don't.
You just don't know,
I
right?
just don't know because there's no numbers.
All right. So here's the thing. Give it back to me. Here's the thing. As soon as you get your license, you got to start marketing. So one of the first things you're going to do is a business card, right? When you do a business card, you're going to take the sharpest picture you can get. I'll show you pictures that I have on my computer right now for business cards. And if you see the person and you see the picture, you're like, nah, it's not the same person. See, for the business card, for some people, it's the first time they actually dress up. You see what I'm trying to say? Now, you cannot look at something like this and say 5, 10 years because of the suit or because of the card, right?
Right.
Because you know the person, you have a different perspective. Does that make sense? Well, you know the person, but you went like, oh, you can't tell. But as soon as you get your license, the first thing you do is business cards because you introduce that to the people. If it's somebody you don't know, you're going to look at it and like, oh, okay. They got experience, 5 to 10 years, right? So I'm going to use them because they have experience. But you just got your license yesterday. What I'm trying to say with this is, it doesn't matter what business card you have. Doesn't matter if it shows how professional you are. By you just getting the license, doesn't mean you're a pro. In fact, you know nothing. So by virtue of your license, you're expected to know. But if you don't, you're also expected to work with somebody else that knows. You see what I'm saying?
Yeah.
Because if you don't know, even though you presented yourself as you did, the client's entitled to sue you because you're the licensed one. You got it? Business card, license means nothing. You're supposed to know. Okay? So if you go to the next page, it says breach of duty of care. So the duty of care requires the sales agent to, among other things, be knowledgeable about all aspects of the property, to arrive at a reasonable listing price, to discover and investigate material facts, try to negotiate the highest possible sales price, meet deadlines and closing dates, and advise the seller on ways to effect the sale. Failure to be properly informed about the property's condition and value and to effectively navigate the transaction through closing constitutes a breach of duty of care. And I'm not going to read the buyer, but it's the same thing. So when you hire by someone, okay, do you have a personal trainer or no?
No,
Why not?
because I can't afford it.
Okay.
But if I could, you know, I would get,
Right.
you know, the best, you know, the better one, because
So if
I'm
you
paying
could
for,
afford,
the person, to do something for me. No,
Okay.
I'm not gonna pay cheaper because, it's cheaper, and he is not gonna
gotcha,
do what I want.
gotcha.
Got
Okay,
it?
you're getting to three things that I usually explain for sale by owners. Okay? So you were a workout by owner. Here's the thing. You're trying to save money by not hiring the personal trainer, right? By saving that money, if you get injured because you're doing the wrong form, whatever it is, that's going to cost you way more.
Oh, yeah.
So for sale by owner, if you don't know all the details of the real estate transaction, it could hurt you way more than my 6% commission.
Yeah.
Does that make sense?
Yes.
All right. Second, you said that a personal trainer would help you with certain things. And mainly it's to reach a goal. Does that make sense?
Yeah.
Because if you have a personal trainer, in your mind is like you want to get fit, or you want to just lose some weight, or you have a problem like I do. I have back issues, so back problems, so I have to have somebody help me do exercises. I cannot just do it on my own because I could damage my back. I know how to do it because I used to go to the gym, but because of the problems I have, I need somebody to say, okay, for your back problem, this exercise, no. If you want to do it, we'll do it this way, not to hurt you more. Does that make sense?
Yeah.
So a personal trainer, just like us realtors, the idea is to hold your hand and try to reach you to that goal. Does that make sense?
Mhm.
So saving money, yeah, great. What if you get hurt?
Yeah.
And third, they're supposed to be there for you to reach that goal. But we also know that even though you have a personal trainer and they say, hey, nutrition is supposed to be this way. Next day you get there and they go like, did you have the meal I told you to have exactly as I told you to have? I'm like, sure I did. Right?
Yes.
You're like crossing your fingers, oh, sure I did.
Mm-hmm.
Liar, right?
Mm-hmm.
And the coffee was with no sugar, right? Yeah, it was wine. What?
He said it when I brought my cup today.
What?
What? Yes, he
It
said
almost
that.
has the color and everything.
So
Anyway.
I knew that he's going to say that.
The bottom line is, when you represent the seller, we are like personal trainers for real estate. You represent the buyer, personal trainer for real estate. Your job is to know the whole process beginning to end, advise the whole process beginning to end, and hold them accountable in every step of the way. Because as a realtor, we don't do anything, by the way. We don't. We just tell the seller, hey, Mr. Seller, you need to do this, this, and that. Get it done.
Mm-hmm.
Oh, but okay, I got this person that will help you with this. That person that will help you with that. Here's the attorney that will go through closing. Does that make sense? Our job is to coordinate. The same way that when you go home, you're supposed to have that meal. I'm not going to go there and feed you or prepare the meal for you, but I'm advising you. So we're advisors. Does that make sense?
Mhm.
Our job is to know the best for them. And on the third paragraph, it says, the agent is expected to deliver quality of service that a normal person would expect of a reasonably prudent agent. So actions breaching this obligation might be failing to present written offers before it expires, neglecting to mention in the purchase contract any fixtures or personal property desired by one of the parties, neglecting property being managed for another, improperly handling escrow deposits, or failing to obtain all necessary signatures on the contract, which I mentioned yesterday, right? I said that Rick was top producer and always forgot a signature. So these are things that could be failures. If you go to the end, right above obedience, it says the rookie, you see rookie residential agent, confronted with an opportunity to list a shopping plaza, should probably approach an experienced commercial broker with a request that they work together to list and sell the property. Like I said, you have no experience. You already have no experience in residential. But hey, you have an opportunity to list this building. What are you going to do? You got to work with somebody that has experience. That's your duty, is to find people that will help you get the job done. Because if you try to do it yourself, and then the transaction does not go through because you failed, you can get sued. A lot of agents are like, oh, didn't go through, and now I can walk away. No, you can get sued for being incompetent. And being incompetent is not insulting, it's just the fact that you did not do what you were supposed to do. You got it?
Mhm.
So it says, otherwise, the duty of observing an appropriate standard of care may be breached by an inexperienced agent. The next one is obedience. That's the second thing that's very important for you to understand, is that if the client tells you something, you must obey, as long as it's lawful instructions. If it's something that will cause you to lie, then that's not lawful instructions. Like if there's mold in the basement, and you know about it because your client said or because you saw, and the client goes like, hey, you know what, I'm gonna paint this tomorrow, don't tell anybody that there's mold. You can't do that. You cannot accept that instruction. Does that make sense?
Yeah.
What you can accept is like the agent must obey the client's lawful instructions such as 24-hour notice for showing, or all offers through the listing broker, or all contracts must be accompanied by a pre-approved mortgage letter. What I do is I tell the seller, hey, let's put these conditions. I don't wait for them to tell me, I tell them. Why? 24-hour notice of showing is very simple. If somebody calls you today at 5 o'clock to show the house at 7, you're just getting out of work. Why would I bother you saying, hey, I want to show the house at 7? I don't know how you left the house this morning. You got kids. So I don't know if rushing out of the house is a mess. If I bring a client there, potential buyer there, they're going to look at the mess and not at the house.
That's true.
So that affects, that's true, right? So that affects the potential value of the house. You got it?
Mm-hmm.
So that's a breach. All offers through the listing broker, that means, hey, if you hired me, then all offers should go through me. Why? Because I can evaluate the offers properly. You won't know what's the difference between a conventional FHA, cash offer, or any other option out there. But I know. And sometimes cash is not the best. Most of the times it is, but because you can close faster. But sometimes it's not. Does that make sense?
Mm-hmm.
So go through me. And the last one is, this for me is like a mandatory thing. All contracts must be submitted accompanied by a pre-approved mortgage letter. Why? Because if you bring a buyer to me, I want to make sure that the buyer is ready to buy. Does that make sense?
Yeah.
Mm-hmm.
How do I know that? If somebody approved them. Does that make sense? Or they have cash in the bank. Show me proof of funds or something. Now, Mr. Seller, you allowing me, this is part of training to our agents, by the way, but Mr. Seller, you're allowing me to reject contracts that don't meet this standard. So I won't bother you with offers that don't bring the approved letter. You guys understand?
Mm-hmm.
So these are
Filters.
filters, yes. So on top it says some instructions must be disobeyed. I already covered that. Like, hey, don't show properties to this type of people, like Peruvians, for instance. We don't want Peruvians seeing houses, right? It's horrible, especially if they're married to Brazilians. Even worse.
Yeah.
Oh my God.
Terrible, right? So what I was trying to say here is, for instance, if you put something specific like that, that's discrimination. If your client said, like I said the mold already as an example, but if your client says, don't show the house to any of these type of people, then that's discrimination. It's also unlawful. We'll talk about that tomorrow, the day that he's not going to be here. Are you actually going to be here?
I made
discrimination?
arrangements.
Arrangements.
All the Wednesdays.
All right.
Oh, okay.
So on time, you mean?
Yeah, no, I'll be here on time.
Okay.
Even better.
All right. Imagine when I have 50 people in my classes and I do this to every single one.
Wow.
It's gonna be fun.
And they still love it though.
Yeah.
I usually say this, if I ever offend you, just talk to me after and I'll stop picking on you. I'll stick to them. All right, accounting.
Okay.
Accounting, I already told you what it is. You have to keep safeguard and a proper accounting of all the monies that you handle for somebody else. That's it. Right? So we talked about yesterday, you have a certain amount of days to deposit the money.
Mhm.
Do you know how much it was?
Like 5, 6,
5 business.
10, 5, right?
5 what?
5 business days.
Business, not calendar. So if I gave you the money on a Thursday, remember that?
Yeah.
By Wednesday, yes. Now, at the bottom says something that's funny. It says an agent may not make any secret profits. What is a secret profit?
Like extra money on the side, like a you.
You cannot make extra money on the side? Who said that?
A kickback.
Wait. Kickback.
All depending.
Okay. So, what is secret profit? You telling me I cannot make extra money
If it's not
on the
written.
side? It could be on the side, on the front, on the back. It depends on if it's disclosed or not.
Yeah, if it's not on the contract.
So under the table, that's what you were trying to say.
basically,
Yeah.
Yeah.
So if it's not disclosed on the contract, then you cannot make that money. So if you make tips, we call them bonuses in real estate, and you can have bonuses. If you make tips, it's okay, as long as it's on the contract at closing. It could even be said, hey, it's not paid out at the closing, it's outside of closing. So you write POC and whatever which is paid outside of closing, and whatever the amount is. Does that make sense?
Mm-hmm.
So anything that's hidden, related to transaction that's hidden, is illegal. If it's disclosed, you're good. And please, ask for bonuses every time. You never know when you might get it.
Yeah, that's true.
So you ask all the time?
Oh yeah,
Oh my God.
$5,000 bonuses, yeah. If it's $1 million house, it's $10,000 bonuses.
On top of that 10% commission.
On top of the 10% commission, there you go.
You know your worth.
That's it.
It's not 6?
Listen, it's 6. I don't work for 6. I taught a realtor how to do that. One of my students became a realtor, and I said, hey, you start negotiating at 10%, and you might land on 8 or 7, which is way better than 6 or 5, right?
Mm-hmm.
Guess what? The very first listing in Hoboken, very first listing, 7%.
Wow.
Just because people follow instructions. Some. Others study the first 20 minutes right before, the last 20 minutes before getting here. Some don't even study, and I mean. All right, so breach of duty of accounting. Don't worry, when I was studying, I did the same thing you guys are doing. You already know any money received must be scrupulously accounted for. We covered all that yesterday. Loyalty. Before we read, what does it mean to be loyal?
To be loyal for your customer, to be loyal for your seller, buyer, whatever, for your company.
You're just saying loyal. It doesn't.
Loyalty.
What does it mean to be loyal?
Trustworthy. No.
Getting there. It is trustworthy. There's one more.
Loyal. To be honest.
All right. You know what? I'm stopping right here.
Stop.
I'll stop counting.
Yeah,
Who's
mine.
married? Who's in a relationship? 3 of you.
Funny.
And
Like,
none
we
of you
put
know
our
what it
hands
means to
up.
be loyal? What?
We put our hands up for marriage, but
Um,
when are we in a relationship? We put our hands up.
That's a question, right?
Yeah.
It's questionable.
You're not cheating, no.
So trustworthy, not cheating. And if somebody,
Faithful.
faithful, there you go.
Okay.
There you go. See?
All
It's
right.
pretty
It
good.
took some time. It took some
does.
time. Like 20 seconds?
I know.
Wow.
Yes.
I should talk to your significant others.
It's okay.
Forget diapers. Forget the kids. Anyway, the point here is when somebody trusts you, they will confide in you and tell you things that could affect the transaction.
Mhm.
Like, for instance, if a seller says, I'm going through a divorce, that's why I'm trying to sell. Are you going to say that to the buyer?
No.
No, because it affects the transaction. We went over this yesterday, right? We talked about it. The same token, if the buyer has more money than what they're offering, you're going to tell the seller, hey, this offers $200,000, but they have $500,000 in the bank. No, because then the seller wants a counter for more. So if they trust you, you got to be loyal to your client and confidential. That's what it says. It includes confidentiality. Okay? Good?
Good.
Mhm.
Now you guys know what it means to be loyal?
Yes.
All right, cool.
Learn how to be loyal. Yeah.
I just saved your marriages.
I don't know.
Next, we have,
Let's watch the kick.
I'll give you a break in a second. Yeah.
It's kidding. It's a lot.
It is. Actually, I'll see if we can finish today. 'Cause
And
it's,
if you're spending like 25 seconds, to answer a question, it's gonna take more, right?
yes. Mm-hmm.
You need to be faster.
That and people getting here on time, you know, it delays everything else. Asking for toilet paper towels.
Yeah, have toiletries.
Toiletries. All right, breach of duty of loyalty. It says because the agent may not advance his or interest at the expense of the principals, like trying to get a deal done because they found out some information. Any attempt to profit from the transaction except through an agreed on commission signals a situation in which loyalty might be breached. So very important, profiting from a client's misfortune, like the divorce for instance, is forbidden. So if you get caught because you leaked information, inside trading, same thing, you're done. You lose your license. Disclosure. What we're saying here is that you have to pass along, so that's what I said earlier, you have to pass along as much information as you can regarding the property. Because if there's mold, it affects the value. If there's structural damage, it affects the value. You're not responsible to know these details, but you're responsible to inquire about them. Does that make sense?
Mhm.
So if the seller says, yeah, there's mold, or if you saw it actually, then you have to report it. If it's hidden, then you don't know, right?
Right.
So the seller's responsible for letting you know. We're going to cover that in a little bit. If there's an inspection and you know the inspection report, you must pass along to the potential buyer. Okay, these are disclosures that must be given. It says right there, right at the end of that paragraph, any information that might affect the object of the agency, the true value of the property, and or possible legal consequences of contract provisions. What I'm trying to say is anything and everything that could affect the transaction must be disclosed. All right. Next, we have breach of duty of disclosure or notice. Again, as I said, the law considers that any notice given to the agent has been given to the principal. Just like I said yesterday, if you receive money, you as a salesperson, so did your broker. Even though you only gave it to them on Monday, from Thursday to Monday you held the money, it's deemed received the moment it went to your hands. So here it's the same thing. On the right-hand side on top, actually on the right-hand side where it says broker-salesperson relationship, do you see it?
Mm-hmm.
I'm going to go briefly over this because we covered yesterday. It says that a person licensed to perform any real estate activities on behalf of a licensed real estate broker is known as a real estate salesperson. You guys know this. But a salesperson is responsible to the broker under whom he or she is licensed. What does that mean? If you're sponsored by RE/MAX, then you only represent RE/MAX. That's your flag. All right, we'll give you an example. There's players out there that are sponsored by Nike. They cannot be seen wearing Adidas or Reebok. That's a big lawsuit for them. They have penalties they have to pay. So if you're represented by sponsored by RE/MAX, and you're saying how good Weichert is and like their houses and trying to get paid from them versus from your broker, then you're breaching your contract with your broker. Okay?
Mm-hmm. I saw something like, when you work in a restaurant, they only sell beverage from Coca-Cola. They can sell something, from another company.
From Pepsi.
But those are contracts, yeah.
Yeah.
Those are contracts. Before I get supplies from a particular supplier, they usually lock me down. So in certain places, like Applebee's for instance, you don't have Coca-Cola, you don't have Pepsi, you have RC Cola. It's like the cheapest you can get, and that's the contract they have. Does that make sense?
Yeah.
Mm-hmm.
So when you say you want Coke, you should have asked. And then they say, oh, it's, some of them they actually go like, it's RC Cola, or it's Pepsi, or it's actual Coke. Some of them say it. Others are like, hey, Coke, okay. And they put that cheap stuff.
Mm-hmm.
Anyway, so these are contracts. Very important. You don't mess with contracts. Salesperson and the broker. Where it says salesperson, that's what we're reading. It says a salesperson, on the other hand, has no authority to make contracts with or receive compensation directly from anyone other than his or her supervising broker. Again, you already know this. You're hired by your broker, payments go through your broker and then to you. The seller or the buyer cannot pay you directly. No other broker can pay you directly. Okay, everything through your broker. And again, it says, you have highlighted there, all of the salesperson's activities must be performed in the name of the supervising broker. Just repeating. Where it says independent contractor versus employee, if you guys go to the next page, it says that the employer-employee relationship allows a broker to exercise certain controls over salespeople who are employees. So if you're my assistant, you're an employee, okay? So as an assistant, I can say, hey, you got to be here from 9 to 5, answer the phones, do this, the attire, what you're going to dress like is going to be this way. If there's a meeting, it's mandatory, you have to be here. So if you're an employee, you got to follow certain regulations. Being independent, which is what most real estate salespeople are, being independent, hey, you're your own boss. You're sponsored by me, but you do your own hours, you pay your own insurance, you pay your own taxes, everything's on you. I pay you, and then you're responsible for everything else. You don't have hours, you don't have mandatory meetings, you don't have anything. heck, if you don't want to work, it's up to you. Does that make sense?
Mhm.
So employee, independent. Independent, you're your own boss. Employee, you follow my rules. If a broker, so this is a question, if a broker tries to impose certain hours to the independent, then the broker is treating you as an employee. Therefore, have to report to the IRS as an employee. Okay? Yes? Ah, it's on the test.
I'm gonna get that money.
That's it. All the way at the bottom, we got broker's compensation. So it says, you guys already know the compensation is based on the contract. That's it. So second sentence there says, compensation is often computed as a percentage of the total amount of money involved, but it can be a flat fee or hourly rate. Usually we go by percentages. But I can say, you know what? I'm going to charge you $10,000, period. Right? Or I can charge by the hour that I work. Most realtors, actually, I don't know of any realtor that does it, but most realtors, they don't charge you by the hour. They charge percentage or flat fee. I'm going to charge you more than this. And why do you want to know flat fees? You guys know what 6% is of 300,000?
$300, 6%.
It's easy. 3 times 6.
18.
18,000. It's very easy. Don't worry, we have the math chapter.
I hate math.
I got you.
They give you a calculator on test.
Calculator without knowing what to do means nothing.
No.
They don't give you Google on the test. So here's the thing. 18% of 6% of 300,000 is $18,000. All you do is, like, if it's 20%, it's 2 times whatever it is. Take a few zeros. If it's 6% is 6 times whatever the value is. Take a few zeros. So $18,000. A lot of people are scared and cannot do percentages. Okay? So they're scared. So you got to be able to, even if you use your phone, it's fine. But you got to be able to tell the client, hey, this is more or less what I'm going to charge you if it sells at this price. $18,000 flat fee. Does that make sense?
Yeah.
Because people are, scared of percentages. Now, the commission or fee is usually considered to be earned when the broker has accomplished the work for which he or she was hired. Unless there's an agreement to the contrary. After a listing broker procures a ready, willing, and able buyer, the seller, go to the right-hand side of the top, the seller is technically liable for the broker's commission. A ready, willing, and able buyer is one who is prepared to buy on the seller's term, is financially capable, and is ready to take positive steps towards the consummation of the transaction. So what we're saying here is, the moment you find a buyer that's ready to buy, willing to buy this particular property, right, and able, meaning financially able to buy it, then you earn your commission, right? So when do you think you get paid?
6%.
No, when? Not
When?
how much.
After the closing is done.
After the closing done. That's when you get paid. But when do you earn your commission?
At the moment they sign a contract.
Boom. Okay? So you earn your commission the moment there's a contract, because you accomplished what you were hired for. My job is to find a ready, willing, able buyer. I did find one. If we close, I get paid, but I earned it now. So even though the fee is actually earned earlier, most contracts provide that the fee not be paid until the actual sale, transfer of title, which would be closing.
Okay.
Does that make sense?
Yeah.
So there's a question in the state exam, which is when do you earn it? At time of contract. When do you collect it? At closing.
Okay.
You got it? It's a big difference. Now, do deals always go through?
No.
Of course not. In fact, most deals will not go through. There's always a problem. Sometimes the problem is you, sometimes the seller, sometimes it's the buyer, sometimes the title company, mortgage company, whatever. There's always a problem. Some people are able to get around the problems, others get stuck with the problem. And that's why deals don't, like, you gotta get creative. I'll let you know right now. You gotta get creative. You gotta talk to the mortgage company, hey, what if we do it this way? Is it okay? And they'll tell you, according to their standards, then we change. Title company, I know there's a problem there, but if you can get resolved within a certain amount of time, or if the buyer agrees to pay for that, whatever issue it is, can we still close? Does that make sense?
Mm-hmm.
And sometimes we can, you know, sometimes we're at the closing table and the deal falls through. We're about to be done and the deal falls through because of these small things. So, because deals might fall through, it says if such occurs for any of the following reasons, you might still be entitled to a commission. For instance, the owner changes his or her mind and refuses to sell. How is that your fault?
It's not.
It's not. There are defects to the owner's title that are not corrected. How is that your fault?
It's not.
The owner commits fraud with respect to the transaction. How is that your fault?
It's not.
Hopefully you're not involved either, right? So what I'm trying to say at the end of the bullet points is that a broker is generally due a commission if a sale is not finalized because of the principal's default. Right? So if it's a seller's problem or the buyer's problem, but you did your job, you might be entitled to commission. How many times are you going to get paid? Probably none, because it's a lengthy process, and most attorneys just say, hey, it's not worth it.
Yeah.
If it's a bigger deal, yeah, we're going to fight for it. Okay? Go to page 31. On page 31, it says the broker is usually entitled to a fee if he or she is the procuring cause of the sale. That means, like I said before, you found a ready, willing, and able buyer, right? Meeting of the minds. So you're going to see this term and hear this term a lot. Is said to have taken place when the parties are in agreement on price, down payment, and financing method. So you're the buyer, I'm the seller. You put an offer. I look at the terms of the offer and I say, okay, price is good, I accept. It's an FHA or condition is that the drapes are included or the fridge is included, whatever, right? So if I agree to everything that's on contract, then we have a meeting of the minds. My mind is set and it's in agreement with your mind, set. So contract moves forward. Does that make sense?
Yeah.
Is that a time of contract?
No, it's time of acceptance.
Okay.
Because you put an offer as a
At the time
contract.
of
The moment I
signs.
sign,
Mhm. Okay.
see, to put an offer, you sign as a buyer.
Right.
It comes to me. The moment I sign as a seller, that's agreement. That's meeting of the minds.
Right. Okay.
Compensation, you already know that could be salary, split, whatever. We talked about that. Now, on the right-hand side, right above disclosure of agency. Again, I already covered this, but it says a broker has the right to reject any agency contracts that in his or her judgment violate the ethics or high standard of the office. And in fact, please put a star next to this, must reject contracts that will cause the broker to violate the law. Like I said, if you know something that's damaged and they're telling you to hide it, violates the law. If they say no Peruvians, then that violates the law. It's discrimination. I don't know why, but it's discrimination against them for some reason. And their garlic, right?
Because we're so tall.
Exactly. However, after a broker relationship has been established, the broker owes the principal the duty to exercise care, skill, integrity, and carry on instructions. So if you accepted it as is, now you're as liable as they are, but you have to carry on. Does that make sense?
Mm-hmm.
What I will do, and what they suggest to do later on, is that as soon as you find out something that's damaging to the transaction, you explain to the seller or to the buyer, hey, I'm not doing this. You talk to your broker and try to get out of the deal. Break the contract versus breaking the law. Does that make sense?
Mm-hmm.
I prefer to lose money than lose my license.
Exactly.
Okay? Now, the exam has 110 questions. We covered that yesterday. Out of 110 questions, there's 22 chapters, so that means 5 questions per chapter, right? But this section alone, where we're going to go over, this section alone has 5 or 6 questions. So it's not a chapter, it's a specific section with 5 or 6 questions just related to that. And that's disclosure of agency. What is agency? It's the business relationship we have. Employer, employee. You got it?
Mm-hmm.
So, New Jersey regulations require licensees to present a consumer information statement, which is a CIS, and you're going to see this a lot. It's a form of disclosure. It's not a contract, it's just a disclosure. Okay? And that's very important to know. This is just a disclosure. It's not like, hey, now you have to work with me. No. It's where I tell the seller, the buyer, landlords, and tenants on the sale of rental or 1 to 4 family residential properties and vacant 1 family lots how we could represent them. Okay? It says, after, so the last sentence there says, although a consumer information statement is not required for other transactions like commercial buildings or multi-unit apartments, written disclosure of agency can be a prudent precaution for the broker in all situations. What does this mean? Cover your assets. See, whatever you're going to say is not what gets sued, it's your assets.
Mm-hmm.
I don't know why they came up with they shorten it, American way, shorten everything. It's cover your assets, because when you get sued, you could lose the house, the car, everything. Okay? So CYA, that's what it is. Make sure you put a bunch of stars in the next paragraph. It says the consumer information statement. The consumer information statement describes types of business relationships, underlying business relationships, that a real estate agent can enter into with a customer or client, and the duties associated with each relationship. A real estate agent can function as a seller's agent, buyer's agent, disclosal agent, or transaction broker. That's how we started this chapter, right? We talked about this. Yeah. Right? There's another one there, but it's not as important for the exam. These 4 core ones are. Again, seller's agent, you represent the seller. Buyer's agent, you represent the buyer. Disclosal agent, underline disclosed, you represent both and they know about it. Mm-hmm. And transaction broker, you represent none. You represent the transaction only. Okay?
I just have to get the lawyers.
Yeah. They don't have to.
Oh, no. You don't have to, but
you recommend. I want you to go to page 36 and then we're going to come back, okay? I need to move forward and then move back a little bit. Page 36. It says furnish the consumer information statements. Yes. Furnishing is providing, right? Giving. So it says here real estate agents are required, and you have to remember this, are required, so circle required, to furnish a CIS before any discussion, underline any, or circle any discussion, of a seller's, landlord, or buyer's tenant motivation or financial situations initiated. So if the first discussion takes place by telephone or in a social setting, the seller or buyer must still be verbally informed about the possible agency relationships and alert to their implications. So we're going to stop right here. What we're saying is, you call me up and be like, hey, Bruno, I want to buy a house. I'm like, okay, stop right there. Before we proceed, I must disclose something to you, mandated by the state. Is that okay? So you get their permission to disclose. Would you listen to me if I said something like this?
Mm-hmm. Yeah. Well.
Decide yourself. So let's find out what the disclosures are. Let's go to page 34, page 35. What does it say on top? On top of both, right?
Yeah.
Mm-hmm. Put stars, fold the top of those pages. Whatever you can do.
Yeah, I've seen this difference before.
You've seen that before?
Mm-hmm.
When?
With my houses.
But did you see it
I think
before anything else or after?
after.
After. Big mistake that their realtor committed. See, here I'm telling you, this is the disclosure. So when somebody says, hey, I want to buy a house, I'm like, hold right there, I need to disclose something. Is that okay? You say, okay. So here's the disclosure. In the Jersey, real estate licensees are required to disclose how they intend to work with buyers and sellers in real estate transactions. In rental transactions, terms buyers and sellers should be read as tenants and landlords respectively. As a seller agent or sub-agent, I, the licensee, represent the seller, and all material information supplied to me by the buyer will be told to the seller. As a buyer's agent, I, the licensee, represent the buyer, and so on. Like, I just covered point 1 and half of point 2. I have to disclose 2 pages. All the way to page 35 where it says acknowledgement. Imagine over the phone or in a social setting, and I'm reading all this to you. No, right? It's not going to happen.
No.
That's why most realtors, even when they sit down to talk serious to you and show houses, they don't present this to you. Right?
Yeah.
Then, you know when they present to you?
When you're doing the contract.
When you do the contract, they slide it there and say, hey, sign right here, please.
I told you I've seen this before.
Mhm. I find out from a student of mine, he's a cop. After the closing, he realizes in his documents that that was there.
Really?
So throughout the whole transaction, that was never provided.
Wow.
How crazy is that? So what we're saying is, as a seller's agent, this is what you can expect from me. If you're a buyer, as a buyer's agent, this is what you can expect from me. If I represent both, this is what you can expect from me. If I represent none, this is what you can expect. Don't you think you should know that before we start working?
Yeah, of course.
That's why it's a disclosure that must be furnished at the first time we talk. You guys understand?
Yeah.
That's a real estate exam question. Is there? And we're going to highlight in a little. I mean, it's highlighted in a little bit. But it says acknowledgement on page 35. That means they have to sign this. By signing the consumer, look what it says. By signing this consumer information statement, I acknowledge that I received the statement from RE/MAX prior to discussing my motivation to sell or lease my desired selling or leasing price with one of the representatives. You signed it at contract, so not prior.
Yeah, exactly.
You got it?
Yeah.
And at the bottom, what they usually tell you to do is where it says date, don't date.
Yes.
Yes. You know why?
No.
Because they backdated.
Oh, okay. Listen, I have a lot to talk to my realtors about.
You just got the wrong realtor. If you need one,
Yep.
I got Rick.
if you need a realtor,
Why am I here?
well, until you were one.
Okay, got it.
Just messing with you. But it's funny because they do this all the time. And the worst part is that their brokers teach them to do it that way.
Really? Well, there's always the in and outs or something, right?
Hey, what you don't know doesn't hurt you, right?
I
You did not know.
Yeah.
Yeah.
So guys, when you buy homes, just pay attention, make sure it's not that first.
Exactly. So if you go next to, again to page 36, where we stop reading, then it says the statement, because we did it in a social setting or by the phone, says the statement should then be furnished at the next meeting or included in the first fax, mailed, or delivered material. If no discussion of motivational or financial situation has taken place, the agent must furnish the CIS before any property listed or unlisted is shown. And the last thing there, it says sellers and buyers, right above further written disclosures. Sellers and buyers must acknowledge the receipt of the CIS on all offers, contracts, and leases. Crazy, right? On the right-hand side on top, it says termination of agency. What is agency again?
The place where,
The place.
You're
No place.
employed.
No place like home.
The place where you're employed, basically.
There's no place. Agency.
it's the group that provides the service that you're looking
Kind of. Agency is employer-employee relationship.
You're not the employee.
There's no place.
Yeah. Okay.
Because if we agree to something right now where you employ my services, this is an agency relationship.
Okay.
Can you say that again? Is
Employer-employee relationship. If you're employed by the seller, you created an agency. Fiduciary relationship was created there.
all right.
No, that was not a question on the
No,
exam,
it
but it's
wasn't.
something similar to that.
Yeah.
If you understand this, then the question that you have on the exam will be clear. Okay? So it's not a place, it's a relationship.
Got
Okay? So how do we terminate agency? So think about it. Termination of agency, you're going to terminate the place? No. It says the agency relationship may be terminated by any of the following: death or incompetency of either party, destruction or condemnation of the property, expiration of the term of agency, mutual agreement to terminate the agency, renunciation by the agent, revocation by the principal, bankruptcy of either party, and hopefully the only reason why the relationship ends is because you completed what you were hired to do, which is close. And that means to you,
Good money.
Cash money.
money. Happy client and happy agent. Okay?
Wife.
Happy wife, happy life. I don't know about that one here. Oh yeah, after you get paid.
After you pay.
Yeah.
Oh,
Okay. Allie's like, yeah.
Yeah. No comment.
No comments. All right, buyer is the principal. We talked about that yesterday and a little bit earlier. Right at the bottom it says, if the broker represents both parties in the same real estate transaction, he or she can collect from only one. So that's very important, because you cannot negotiate the 6% with the seller and then try to negotiate 6% with the buyer. What happens is either the seller pays or the buyer pays the full commission, but it's one or the other. Okay? You get paid the full commission, but it's either from the seller or from the buyer. All right, dual agency already covered, right? A couple pages ago. So already covered dual agency. So what is dual agency? Is it legal? It's illegal? Dual agency.
Illegal.
Without reading?
I didn't, I was quoting it.
No. So
Oh,
and what did you say?
illegal.
Dual agency is illegal.
Yeah.
Kind of, yes. Do you agree with that?
No, it's legal, but it's legal, but both parties have to be disclosed.
Correct. So undisclosed dual agency, meaning the seller does not know you represent the buyer, or the buyer does not know you represent the seller as well, that's illegal. So it must be disclosed. That's why on the next page, it says, I'm going to give you a break in a second. Now you're like, oh, it's not.
No, that was just here. So many
Yeah.
difficult things. You know,
Letters.
So much text.
Ooh.
It says that simply giving the buyer mandated consumer information statement or CIS is not enough. So then it says disclosed dual agency is legal in New Jersey if the broker explains fully the legal duties that will and will not be available. When do we disclose what you can expect from me?
Beginning.
At CIS and again at contract. See, at contract, you sign twice the same thing.
Right.
One was the CIS and the other one is the actual contract that says, I represent you this way. So you should have known before. You have to disclose any other business relationships that might affect the proposed transaction, like if you represent another party in the deal, or if you have a special interest in the deal. Like if I sell my church, as an example, I'm part of the church and I'm trying to sell. Conflict of interest? I know. So it's a conflict of interest. Because if you have a special connection to that transaction, or your grandmother's house, or whatever, you should disclose, hey, by the way, I represent the seller, and that seller is my grandmother. Right? They should know, because then are you gonna be biased? Maybe? No? You see what I'm saying?
Yeah.
Very important, you gotta obtain the buyer's and seller's written informed consent to the brokers acting as a dual agent, so that's part of the contract. And advise that each party may want to consult a lawyer. May. Yeah, you're not obligated, okay? You may. Why? Because if I represent both of you, I'm not representing your best interest or your best interest. But if you have your own attorneys, then they'll represent your interest. Because an attorney cannot represent both sides. On the right-hand side, you have conflict of interest. Do you see it? Okay. Conflict of interest may occur when the agent is called to a listing interview and finds that a seller is ready to let the property go at a ridiculously low price. The courts have held that even though the property is not yet listed, the seller is relying on the broker's expertise and may become a principal. So the licensee who decides to buy the property immediately without notifying the seller of its true value is operating under conflict between his or her own interest and that of the seller. What we're saying here is, Patricia, I go to your house. You want to sell the house, you contacted me, and I go there to help you. Before I go there, if I'm a good realtor, I already went there with comps, meaning I did an evaluation of properties around the area, and yours should be similar to those in terms of value, right? So I get in and I say, hey, let me see the house so I can get better details. By the way, how much do you want to sell it for? And you say 100,000. In my hand, I have a document. So in my hand, I have the comps. And I keep it like this because I'm waiting on your, right? And you say 100,000. Here, I have comps that show 400,000. And I said, 100,000? You know, let's not sell it. I buy it. I think your house is a great deal and I'll take good care of it. And I'll buy the house. See, that's a conflict of interest. You're not my client yet because we did not sign anything, but I took advantage of you because I'm the expert. And you were trying to hire me. Does that make sense?
Yeah.
So if I want to buy your house, I should have done this. Hey, your house is worth 400. Why 100,000? And then you go like, I don't care. I just want 100,000. I need to move out, whatever. Now that I told you the true price, and you still want to sell it for 100, let me call the title company. We're closing now.
Yeah.
Does that make sense?
Yeah.
But only after disclosure. That's what it says. Without notifying the seller of its true value, then it's a conflict of interest. Okay? If I told you the true value and you still want to sell it cheap, right?
Then that's your fault.
That's it. Now, where do you find these deals, by the way?
Not even.
You want me to let you know?
Yeah.
Then I'm going to have to kill you.
Half of the interest.
Stop recording.
Off the record. Probate court. Family court. Seeing divorces, they're just trying to get rid of it.
Yeah.
Any cash quick is good.
Oh my God.
Probate. Unfortunately, siblings, they fight over the money. They don't care about the parents being dead.
Yeah.
They want the money. I don't want to manage that. I live in California. I'm not going to manage a property in Jersey. So let's sell it. Oh, but it's going to take to sell it cheaper. You got it?
Yeah.
So that's where you find these deals.
Yeah.
I just did it.
No, let me know.
Now go to court
Give me
and
some
find it.
Yeah, and that one.
Disclosure issues. We already covered a lot of this stuff, but material information, I just want you to write in front of it, is anything and everything that could affect the transaction. Anything and everything that could affect the transaction. It talks about the physical condition of the property, any information that could be of importance, right? And that's it, so we can skip that one. Only because I already covered it. Go to page 39. Page 39, the second sentence there says licensees. Who are the licensees? The salespeople.
Salespeople.
Now, does it say seller's agent or buyer's agent?
No.
It says licensee. So if you're licensed, you must disclose defects that are uncovered by a reasonable inspection. What do you guys think it's a reasonable inspection?
Like a general inspection?
Like what?
Like,
You're a licensee. What kind of inspection do we do?
Whatever you can see.
Visual. So reasonable is you walk through the house and you looked up, you look down, around,
there's no.
and what you could see. We are now responsible to climb, lift this up, and look what's there. So whatever is reasonable and we can see, then we must disclose. Then it says that sellers, so sentence out that says sellers should be aware, however, that the courts have ruled that they are responsible for revealing any hidden or latent defect to their real estate agent. So if I cannot see, but you know about it, you have to tell me. Because when I go, we're going to cover this in a little bit, when I go to court and I say, hey, Your Honor, I saw what I saw, but I did not know about that. So the judge is going to put all the fault on the seller. So sellers should be aware. Usually I'll tell sellers is, listen, I'm like your doctor. If I don't know all the problems, I cannot help you. And then it could backfire.
Right.
Does that make sense?
Yeah.
And do you guys remember how long you have to sue?
6 years.
6 years.
6 years. So Mr. Seller, you could get away with it now if you don't tell me. But within 6 years, if it's discovered that there's a defect, they can still come after you. You watch them say everything real quick.
Quick, yeah.
Okay? Some of them will be like, hey, I'll be in Peru, so it doesn't matter.
No extradition.
No extradition, I know. Just like Cape Verde. It's, go to Africa, you're there, and it's like, yeah. I know already, the no extradition. Macau, no extradition. Alright. Did you ever buy a car? Car, you all buy a car? Did you ask for a report on the car?
Yeah.
What's it called?
Carfax.
Carfax. She just went blank for a second.
Yeah, I did. You saw that, right?
That's alright.
I thought it was Charlemagne. Sorry.
Carfax. Carfax, right? That's where you list the accidents or any claims against the car, right? Or insurance. Do you guys know that there's one for houses as well?
And isn't that like the title search?
No, title is problems with title. Does not talk about there's damages.
Oh, okay, no.
I'm talking about damages.
Oh, no.
If you have an accident, or
Any claims, insurance claims, and all that stuff. Do you have any clue what it's called? Any clue?
I thought it was comprehensive something, but I think it says here it's clue.
So if you have no clue, it's called an excellent source of information about past problems in any given building is the Comprehensive Loss Underwriting Exchange or clue report. So if you have no clue, just get the clue report.
okay.
What I'm telling you right now is in the exam, there's two answers. They are very similar. One of them says CLE, the other one says clue. Now, they don't have acronyms. But what it says there is Comprehensive Insurance Loss Exchange. The other one says Comprehensive Underwriting Loss Exchange. So, loss underwriting exchange. But in your mind, you see insurance. We're talking about insurance claims. So you're going to answer CLE versus clue. What I'm trying to tell you is that underwriting is risk assessment. So if there's damages, they underwrite based on that. The correct answer is whatever matches clue. Okay? Or if you got no clue, just go for that one.
There you go.
All right. Last paragraph there says New Jersey Administrative Code, NJC, right? Says that social conditions and psychological impairments are not considered physical conditions. So if it's not a physical condition, it does not affect the property. If it does not affect the property, then it doesn't have to be disclosed. Like noisy dogs or unpleasant neighbors do not affect the property's physical condition. So they don't affect the value. It affects your perspective of the neighborhood, but not the value of the property. Does that make sense?
Yep.
Suicide or other non-pleasant events are also considered non-physical conditions. So if somebody dies in the house, do you have to disclose?
No.
No. Should you disclose?
If you were told.
If you know about it, you disclose.
Right. If
If
you
you
don't,
don't know about it,
you keep it
it
up.
says you're not required to research. It says right there, if asked, agents must pass along any information they possess, but they are not required to investigate social or psychological conditions. And before you decide to pass along any of this information, you should consider your agency agreement, right? Your employer-employee relationship, your code, care, beings, and so on. Because think about it. If somebody died there, right, how does that affect the value of the house?
It doesn't.
It doesn't. See, for some people, will be like, oh no, I'm not buying because
Someone
someone died.
Yeah.
Other
I'm afraid
people-
of ghosts.
There you go. Wait, that's you. That's you. Other people will be like, whatever. People die every day. Other people will be with the flashlight waiting for the ghost. And they turn it into a show. We call it Ghost Hunters.
Yeah.
They spend 4 hours there filming nothing. Look, a light. Anyway, so everybody has different perspectives. That does not mean that the value was affected. Okay. Off-site conditions on the right-hand side on top. What do you think off-site means?
Not in the property?
Not in the property. So it could be your neighboring property.
Right.
Your neighbor or a few blocks up, or in this
Across the
case, we
street.
talk about half mile up.
Okay.
See, in 1995, several families sued the developer and a broker, alleging that both had known that a development was located half mile from a hazardous waste dumping site, right? And they failed to disclose this fact. The trial court ruled in favor of the developer, the broker, stating that there's no duty to disclose. I didn't have to. It's half mile up,
I
right?
mean, you should know anyway. You should probably pass by it.
You,
Well,
the buyer?
the buyer.
So I have to drive the whole
No, I'm
city to
saying
figure
pretty
out.
sure the buyer will pass by it on its own, if that's the case, like, you know.
You see what I'm trying to say? You're not going to drive the whole town to figure it out.
No, I'm just
You
saying.
might once in a while go through that
That's what I
path,
mean.
but maybe not. The question is, if it's a hazardous waste dumping site, that means there's chemicals, there's toxins. And usually they're uncovered. So if it rains, it goes into the groundwater. It goes into the groundwater, water does not stop. So if it's half mile up, usually it tends to come down to your property. How would you know?
Mm,
You see what I'm saying?
Yeah.
So on appeal, the decision was reversed. New Jersey Supreme Court ultimately held that conditions beyond the limits of a specific property may be considered material facts and must be disclosed to prospective purchasers. So as a result of this decision, 2 disclosures for off-site conditions are now included in all contracts. One refers to new constructions and the other one to resales. So new construction means nobody lived there before, brand new construction. right?
Mhm.
Resale is, hey, I live there, I'm trying to sell my house. So, new construction, you have a 5-day notice to cancel the contract. Resale, hey, if they handle the green beans, you can handle the green beans. You know what I'm saying? The chemicals and all that.
Mhm.
That's what they're saying. So if they can handle, you can handle.
That's a question.
Listen. I like the way he says it. There's a reason why I stopped him. Listen, by the time we're done with this, I covered all 110 questions and variables of the questions. That's guaranteed. All right? As long as you can remember when you're there. Okay. I know. It's tough.
Megan's Law.
I know some people that get there is like a blank before anything.
I
Like,
heard about that Megan's Law.
so what is Megan Law? Tell me, Allie.
I heard that it's like, familiar.
It's not Megan Trainor, the singer. It's not Megan, the princess. No. Megan's Law. What is Megan's Law? Who can tell me?
Yeah, it says over here, convicted sex offender, whatever,
Okay.
somebody that does abuse another girl.
Sexual harassment laws. Not
Okay.
just girls, sexual harassment
Okay.
altogether. In this case, in 1995, in Jersey,
Mhm.
that's where this law was enacted. In 1995, somebody was sexual harassed, a little girl. And it became case law, and that's why today, even in employment, is so strict about sexual harassment. Okay? So, what I want you to see is in the next paragraph. It says, in New Jersey, and almost every state now, all contracts and leases on residential real estate, residential, not commercial, that are prepared by licensee must include a Megan's Law statement. So every contract says, hey, Megan's Law, there's potential sex offenders in the area, and you should look out for them.
Yes, if it was the sex offender, there's a site.
Yes, in fact, right at the bottom. Yep. It says licensees. Who are the licensees?
The salesperson.
What does it say for the seller or for the buyer?
Doesn't matter.
All, right? So licensees are not permitted, underline not permitted, to inquire about or give any information regarding presence of convicted sex offenders in the neighborhood.
Yeah, there's conflict.
So if I know about it, I cannot tell you, the buyer, even though I see that you have kids. I cannot tell you, hey, next door there's a sex offender. I can't. So like Ali was saying, there's a website. So if a buyer asks, it says, if there's a concerned client, I have it highlighted there, right? If there's a concerned client, then we suggest for them to look at the state website, the state police website. We cannot say, hey, next door, there is one.
Yeah,
But we can say, hey, go online.
just check.
So the rule is we cannot even inquire. Because when you know, you're going to give all the hints.
Right.
My question is, how does a sex offender being in the neighborhood affect the property value?
It doesn't.
It doesn't.
Of course, if you have kids,
But it
people
doesn't affect the
Doesn't affect
value.
the
Oh,
value.
value, okay.
Actual value.
Okay.
No. I've had somebody in my class goes like, of course, I will offer less. Like, wait. You got kids? I went, you got kids?
Yes.
They're like, yeah. So for a lesser price, you put your kids in danger.
Yeah.
You go, no. See, here's the thing. It's not the seller's fault that the neighbor is a sex offender.
Right.
It does not affect the social condition does not affect the physical condition of the property.
It's gonna affect, who's going to buy it, like,
Yeah.
probably
your
no,
choice, yeah.
That's your
no
choice.
family's gonna buy it if they have a kid.
Correct.
Right.
But if it's the seller, the one that's the sex offender,
Yeah, then there's a problem.
no, they're out the door. It's fine. Now it's fine. Now I'll lower the price. Hey, you're a
Right.
sex offender. I don't know about value.
Exactly.
That's different. You're out of here.
Mm-hmm.
Hi.
When they ask you this, they what do you call it? They list different websites. So so they'll list different websites and ask you which is the website you would recommend your potential buyer that's concerned.
And who did I say?
Huh?
New Jersey, state.
No,
Police.
of course.
But yes, they give you different.
They give you
different
some
sites.
websites. Just gotta choose the right one. But they'll list it exactly like this, and they'll NJSSP.
Okay, gotcha.
NJJJSP or something like that.
JJJ.
Yeah, they'll try to mess you up with that.
Okay. One of the questions is what should you do? It might not have been on yours
Yeah.
sometimes because they have different exams. It's not all 110. I know all 600 and something questions, the variables. So one of the questions that it could be is, what do? Do you go research with them on the state website, or do you tell them that for them to just go there? Those variables.
like, for you, like, I can't say the word.
All right, this is blue.
Yeah, you're thinking it's green. You're explaining that it's green, basically.
I just said blue. It's white.
Realtors
I'm
pick.
just, oh,
You're
okay.
colorblind, right?
No, I meant like you.
It's me saying that this is green or this is blue or whatever, and I'm making a statement that it is, but it's incorrect. So if you were colorblind, I was taking advantage of you. Does that make sense?
Yeah.
So it's anything that could affect the person that's buying or selling by making the misrepresentation of the actual fact. So it says right here, extravagant statements of opinion, like you're giving an opinion, is different. Like this house is the most gorgeous view in the world. It's okay, because I'm entitled to my opinion. For some people, the most gorgeous view in the world is looking at Manhattan. Then there's people that pay millions of dollars to look at Jersey. I'm like, doesn't make any sense, right? Millions of dollars. Oh, yeah, Jersey.
Or the Garden State.
The Garden State, where there's no garden. For me, the most gorgeous view in the world is the beach.
Me too.
So if I'm looking at the ocean, that's it.
Sad.
Does it make sense?
Yeah.
But that's an opinion. You can give opinions. So, statements of fact, however, must be accurate and questions must be answered honestly. So, this is white. I cannot say it's green. I cannot say it's blue. This is white. That's what it is, and I have to state like that. Puffing was there? Because that's enhancement of value by making a statement like that. So the broker must be alert to ensure that none of his or her statements can be in any way interpreted as involving fraud, which encompasses all deceitful or dishonest practices intended to harm, like I said, intended to harm or take advantage of another person. If you go to the next paragraph, it says that there's 3 different types of misrepresentation. One of them is intentional or fraudulent, meaning you know that there's damage to the house. And you intentionally or fraudulently tell the person, no, the house is in great condition. How many times have you heard this? Right? All right. You bought a house?
No.
Have you been part of it?
Yeah.
Did you hear this?
Yeah.
And what happened?
It's not perfect.
Nothing's good.
It didn't fall yet. Okay, great.
We were lucky they didn't fall on us when we were looking at it.
There you go. You didn't buy it.
No.
Okay. So that's intentional when you say something that is not. Then there's 2 others. It's negligent or unintentional. Remember I said visual inspection? Okay. So you walk around and you look, right? But you were negligent. You did not look up where there was a spot in the tile, for instance. That spot means that there's a potential leak. If there's a leak, then there's water damage, right?
Yeah.
And this probably is not fixed yet. So you were negligent. You did not do your job properly. Does that make sense?
Yeah.
All right. And then there's the innocent. Innocent is there's no way you could have known because that was already replaced. The mold was already painted. There's no way you could have known that it was damaged. Okay, so there's intentional, there's the negligent, you didn't do your job, and there's no way I could know. Okay? And I covered everything that's there, so go to the right-hand side where it says to avoid misrepresentation. Now, to avoid misrepresentation is very simple. Never present opinions as facts. It's my opinion that we could potentially get $300,000 for this house. But the moment you say, definitely $300,000, and the house sells for $280,000, you made yourself liable for $20,000. You don't tell something, this happens all the time. Realtors do this all the time. Oh yeah, we can get 300, 400, 500, whatever. Like, we're saying we can. But you should say, listen, comparables in the area are going for 400, so yours should bring more or less the same as an opinion. And let the market decide. Does that make sense? Yeah. Next paragraph it says, many requests for information should be met by referring the questioner directly to an expert source. What we're saying is, if you got questions, go to the City Zoning Bureau, mortgage counselor, building inspector, engineer, or even the lawyer. What we're doing is shifting the responsibility or liability to somebody else, the pro in the area. It's not my monkey. Yeah, you know what? You guys got to watch that. Write somewhere. Not my monkey. Terry Watson. Terry Watson. If we have time, I'll play for you right at the end. It's awesome. You learn from the day you watch this video.
Sorry, what?
Terry Watson. From the day you watch this video, you'll change your whole life. The way you do things.
Oh gosh.
Yeah.
No, in a good way.
In a good way, yeah,
In a good way, in a good way.
All right.
Alright.
Consumer Fraud Act. We're almost done. Consumer Fraud Act. New Jersey Consumer Fraud lists in detail all sorts of misleading, fraudulent, and scam practices and sets penalties that include fines of up to $10,000 for a first violation. And it says concealing or omitting material facts about real estate is considered unlawful practice. So if I told you that there's no mold and there's mold, penalties $10,000 or more. So it starts with $10,000 and then there's other stuff that can come with it.
But if you don't see the mold,
Then you,
That's why the Act offers an exemption from liability. So a licensee that had no actual knowledge, you did not know, so what you're saying, you did not know, you're not liable. You make the effort to learn the truth, like you asked for it, or you had a visual inspection, no damage. Or the last one, which is very important, and one of the answers to the question, is the broker or salesperson was relying on information provided by the home inspector or similar specialist, government employee, or the most important of all that a lot of salespeople don't do, which I understand. It's the seller's property condition disclosure statement. It's a document that seller signs. The roof is 5 years old, and they put it there. Is there any mold? Not that I have any knowledge, yes or no. So now the seller's telling me what they know, besides what I see. So you're putting them on the hook. Does that make sense?
yeah.
Now, antitrust laws. So antitrust is like a monopoly, which controls the markets. So the most common antitrust violations that can occur in the real estate business are price fixing and allocations of customers or markets. Price fixing or illegal price fixing is when I'm Remax, that's Weichert, and I go to that, and I start talking about, Remax, that's Weichert, and I'm telling you guys, hey, we're going to do 6% or 7% commission this month. We're going to flat fee. I don't want less, I don't want more. This is what we're going to do. And then one of you talks to your buddy over there at Weichert and says, hey, do you know we're doing a 7% commission this month? We're pushing to 7%. And Weichert, because of this, decides to do what?
Raise it.
Set a standard as well. And commissions are?
And whatever you want to
Negotiable. Correct. So the moment we set a standard in the office, it's okay because I'm pushing you guys to do something. Once you go talk to them, even though it was not your intention, you're conspiring. It creates a control of markets, which cannot occur. Does that make sense? So there's a question that's like very random. Like the way you read it is very like, this doesn't make any sense. Just because I was at a cafe talking to my buddy from another agency, and that's illegal price fixing? Yeah. The moment you disclose what we're doing indoors, it will affect how they do their business. So yes, you got it? The same way with allocations of customers or markets. Next paragraph. Allocations of customers or markets is I go to Weichert broker and I say, hey, across the street, I say, hey, listen, let's make a deal. My office handles properties up to $250,000. Your office handles properties $250,000 and up. You don't interfere with my business, I don't interfere with yours. I'll give you these clients, you give me those clients. That's the control of a market. Does that make sense? So it cannot happen. And usually what I say is if you don't understand this, all the way at the bottom it says penalties for such acts are severe. Under the Sherman Antitrust Act, people who fix prices or allocate markets may be found guilty of a misdemeanor punishable by a maximum of $100,000 fine, I'm sorry, $1 million fine and 10 years in prison. Not bad, right?
Yeah.
All right. But there's more. It's just not the $1 million and 10 years. No. If there's a civil suit, so you pay penalties. But if that person sues you, in the civil suit, a person who has suffered a loss, on the right-hand side on top, a person who suffered a loss because of such activities may recover triple the value of the actual damages plus attorney fees and costs. So it could be way more than the $1 million. Okay, and this is constitutional. You can go after somebody for triple damage. Not bad, right? All right, where it says ethics, liability, disciplinary offenses, we went over most of it. So I'm going to skip. We talked about damages. We talked about lawsuits, a special license, all that stuff. So if you go to the next page, we have something called defense against claims of liability. Would you like to protect yourselves from liability?
Yeah.
Okay, first thing is, put the blame on somebody else. The inspector told me, the seller told me, and so on. Second thing is, because we will make mistakes, we'll make errors, right?
Mhm.
It's something called errors and omission insurance, E&O. That's our protection. Just like when you're driving, you make mistakes, right? So that's why we have liability insurance. In case we hit somebody, that's mandated by state. In case we hit somebody, it's covered. It was our mistake, it's covered. Does that make sense?
Yeah.
Here, we're conducting business, and we might, actually we will, make mistakes. We're human, we make mistakes. Got it? But, it says right there, subject to limitations of a particular policy, it defends against claim as against many circumstances, but does not cover fraud. So if you can be proven that you intentionally committed fraud, right? Because it could be fraud based on other circumstances, but you intentionally committed fraud, then it does not cover, so you're fully liable. And if it does not cover, you're fully liable, what could happen? Lawsuit against you, and they go after what's called guarantee fund. You remember that from yesterday?
Yeah.
Guarantee fund was like the last thing in chapter 1, where they can sue you for up to $20,000, and your license is suspended until you pay it back.
Yep.
Okay? It's okay, don't worry. She still has a pregnancy brain, it's okay. The baby took it all. See, you're here, but your baby is retaining everything.
Yeah, right?
Just wait till he grows up.
She.
Jay.
All right, dual contracts. What do you think is a dual contract?
When you're representing the buyer and seller?
That's dual agency.
Oh, okay.
Verbal? No.
Dual contracts is what it says, it's two contracts.
What does that mean?
Why would you have two contracts? That's what you mean.
Well, I meant like, you represent the buyer and the seller, that's
No.
two contracts.
That's one contract.
That's one?
It's one contract. Because once it becomes a contract, the seller signs, the buyer
Yeah,
signs,
that's right.
you represent both. I'm talking about having two contracts, and what we're saying here is, it's the same house, same seller, same buyer, different prices. Why would you have two contracts? One with the actual price and one with a higher price?
Because that's one that the offer?
No, the offer is not a contract yet, only when it's accepted.
Right.
I'm talking about we finalize it. This happens a lot in car dealers. They do a contract with you, but they submit to the bank something else with a higher inflated price. Why? Because they want more money.
Mm.
Okay? So dual contracts in New Jersey, some other states might be okay, but Jersey outlaws. It's completely illegal to have two separate contracts for the same transaction. Okay? Which brings us
It's
to
only in New Jersey or nationwide?
some states have weird laws.
Oh, yeah?
In Louisiana, it might be okay, like everything else is.
Potential new area.
Wait, I might be teaching too much. I'm sorry, guys.
So one house, one contract.
That's it. Which brings us to ethics. Does anybody know what ethics are?
You said this yesterday.
I did.
But you shouldn't.
You did.
It's basic, your moral compass.
Yes. So, right-hand side on top. Right-hand side on top, it says ethics refers to a system of moral principles, rules, and standard of conduct. The ethical system of a profession establishes conduct that goes beyond merely complying with the law. These moral principles address two sides of a story, of a profession, I'm sorry. One, they establish standards for integrity and competence in dealing with consumers of an industry's services. And two, they define a code of conduct for relations within the industry among its professionals. So, what we're saying here is that code of ethics is how we deal with the consumer and how we deal with each other as business. It happens a lot that you deal with another realtor and things went sour. Later on, that realtor is the listing agent or whoever brings the buyer, and you're like, nah, we're not going to work with them. You cannot do that. You got to be professional enough to still deal with that person business-wise, because it's not your client's fault. If their client's a good client, a buyer, then your seller is going to take advantage of that. Just because you have a problem with another agent, right, doesn't mean it could affect your client's business. At the bottom it says professional organizations, and it says that years ago, real estate brokers realized the need for an organization to assist them in improving their business abilities and to educate the public to the value of qualified real estate brokers. So they created the National Association of Realtors, or NAR, and this was founded in 1908 to meet this need. It says this organization is made up of brokers and salespeople who are members of local boards, associations, and state associations of realtors that operate throughout the United States, and the professional activities of all realtors, active members of local boards that are affiliated with the nations, are governed by the association's Code of Ethics, which NAR adopted in 1913. So it took them 5 years to realize they needed to have some type of ethic, booklet.
Have to test the water first, right?
Yeah, for 5 years, let's screw everybody and see how it goes, and then let's make rules. That's it?
Yeah.
Yeah.
You gotta realize, what is it? If anyone realized it.
Yeah, that's it. On the right hand side, I'm sorry, the next page it says the term realtor is a registered trademark. So what does that mean? It means that unless you're part of the National Association of Realtors, you cannot use realtor in your business card. You can be a salesperson, but not a realtor. Now, a salesperson doesn't sound as good as being a realtor. Realtor is like powerful, isn't it?
Mm-hmm.
Like you're a superhero, realtor. Yeah? Way better. It says the National Association of Real Estate Brokers, do you see it in the red?
Mm-hmm.
National Association of Real Estate Brokers, whose members are called realtists, was founded in 1947 and is particularly active in the South. Its membership, generally composed of African Americans, includes individual members as well as brokers who belong to state and local real estate boards affiliated with the organization. So, National Association of Realtors, they're called realtors. In the red, National Association of Real Estate Brokers, they're called realtists. Okay? You just got to know, if they're realtists, they're from the South. That's what it is. Like the Yankees and...
The website, national...
Nerrev.com.
Yes, what is that?
Huh?
What is that? What is the website?
Oh, just like ours, it's NAR.com. We belong to NAR.com.
Okay.
National Association of Realtors. So for you to have access to your, so we're going to talk about it, to your educational videos, to the marketing resources, to actual designations and training, we go to NAR.com, National Association of Realtors. If you're a realtist, you go to Nerrev.com. That's all. And we have our own Jersey, of course, New Jersey Realtors. The point of this is that we are state, so there's the National Association, and then it's broken down by state. So we are New Jersey Realtors, NJR.com. And this offers educational courses and programs, including specific courses leading to the designation of graduate of the Realtor Institute, so GRI. And you said private associations, it says right there in green.
Shades.
Shades, right? Sorry, you have
Very good. I got it.
I skipped a lot of this stuff because there's not many questions about it, so that's why I went through. But then it talks about designations. I'm going to go very simply over this. It says, as a mark of expertise in various fields, right, professional organizations award designations after required experience, study, and examinations. So all we're saying is, once you're part of the National Association of Realtors, you can become a GRI, Graduate of National Institute. You could become ABR, Credit Advisor Representative. CRS is Certified Residential Specialist. If you're dealing with commercial properties, you want to be a CCIM. If you're a property manager, you're a CPM. My point on this is you don't have to get all the certifications. You just get whatever's related to your niche, to whatever you're focused on. Does that make sense?
Mm-hmm.
There's SIOR, which is for industrial. You know, like if you're not dealing with industrial, why should you have that one? You guys understand? Mm-hmm. So these are designations available for you. Money. The only point is, like, look, if I show up to manage a property and I have, like, hey, I'm CPM certified or whatever it is, right? and I show that on my resume, it's almost like having a college degree. It's what matters for that particular purpose.
Mhm.
That's it.